Hello, everyone. Just waiting for everyone to jump on before we do some of the introductions, but saying a quick hello to our first sign-ons. All right, we'll start with some quick hellos and sort of welcome everyone for attending this. So to our audience, as we're having people join us, and I will repeat a bit of this as we continue. This is our second webinar around Bill 96. As many of you know in the audience, an important topic. It's something that became more and more relevant by the day, and the legislation now having come into effect, it really makes compliance something very important. We prioritized employment HR matters, being that from the series continuation, being that this is some of the topics that most of you are dealing with every day, and there's some pressing questions that a lot of you had. And we thought, what a better way to start with this. And despite it being middle of August, and despite it being peak vacation time, we thought it's important to get started because many of you are planning for September and forward. So I wanted to welcome our two panelists today, Tanya Da Silva and Stephanie Blakely. They're both very knowledgeable around this item, and believe me, we've actually chatted a fair bit with one another on a variety of questions that some of you have had in advance, just to sort of give them an idea of the type of questions and content to discuss here today. But just for a bit of background around Tanya and Stephanie, they're both based out of Montreal, the DLA Piper office in Montreal. Tanya is a partner, and she practices in the employment and commercial litigation and class action area, but she's also done a lot of work in compliance with the French language. Stephanie is an associate out of the same office in Montreal with DLA Piper, also has done a lot of work in commercial litigation, insurance, but also with the French language compliance. They've both been drivers of the Bill 96 content preparation and discussions and leading them internally. And as a result, being true leaders to help us explain some of the items that are pressing with a lot of you. So considering that last time we did when we first started with this webinar, so our first one went over time because there were so many questions. I thought, let's make the most of it, jump into it right away. For housekeeping items, feel free to put in questions even as we continue throughout the presentation. I asked Tanya and Stephanie to sort of take us through some substantive content first, and then we could actually address some of the questions afterwards. I will try not to interrupt them throughout the presentation unless something was really needed to provide clarity or it was critical to that particular point. But otherwise, as we go to the Q&A at the end, we can really address a lot of the questions. I even have some that clients sent in advance, but definitely happy to take any ones that you have here. Tanya and Stephanie were also happy to address anything offline that we don't get to here today. So without further ado, Tanya and Stephanie, thank you for joining us here, and I'll give you and pass along the virtual mic, so to speak.
Thank you very much, Gary, and hi, everyone. As Gary mentioned, my name is Tanya Da Silva, and I'm an employment partner at DLA Piper's Montreal office. And it's my pleasure to be here today to tell you about Bill 96 and how it has modified employers' French language obligations and employee rights under the Charter of the French language. So if we could go to the first slide, please. We're going to just start with a quick overview of the background of this legislation. So first, to begin, Bill 96 amends a bunch of legislation, but mostly it amends the Charter of the French language. And it lists its four main objectives in the following slide. We have that for you, as being the following: to establish French as the only official common language in Quebec, to strengthen the status of French in Quebec in all spheres of society, which obviously includes the workplace, to ensure the state, so the province of Quebec sets an example in the use of French, which means that a lot more of your services from the government will be provided exclusively in French going forward. And to establish a language governance system that is both neutral and strong. Can we go to the next slide, please? So here you see the legislative history of the bill. So very briefly, it was introduced in Quebec's National Assembly on May 13th, 2021. And just over a year later, on May 24th, 2022, it was officially passed with the majority of the National Assembly voting in favor of the bill. And it came into force this year on June 1st. Most of its provisions are already in effect, but some will continue to come in effect over the next 3 years. Next slide, please. So what does Bill 96 do, really, in summary? It makes, as I said, significant changes to the Charter of the French language. It aims to further promote the French language and reiterate the formal recognition of French as the only official language in Quebec. It strengthens the role of the Office Québécois de la langue française, and my colleague Stephanie will talk to you a little bit more about that. It clarifies and reinforces measures currently in force, as well as introduces new requirements and restrictions for employers and businesses in Quebec, not just in the employment sphere, but in various aspects of operations in Quebec. And it includes over 200 amendments to the Charter and to other legislation with respect to French language requirements. So in light of this, I'm sure you'll understand why we've chosen to focus the presentation today on only the HR-related modifications brought on by Bill 96. There's a lot of content there, and we'll have enough to fill our plate just today with the employment piece. Next slide, please. So most of the new employer obligations and employee rights under Bill 96 are already in effect since June 1st, 2022, as I mentioned. And let's begin with the general right surrounding employment, which is the right to work in French. So previously, the Charter already set out that employees had a right to carry on their work in French. Bill 96 has expanded that right to now include an employer obligation to ensure that employees' rights to carry on work in French is respected. So it goes a notch further. There are also new requirements around employment agreements. And this is arguably the most interesting change in my personal view. Previously, the Charter set out that employment agreements had to be in French unless the parties expressly agreed to contract in another language. If the parties wanted to contract in English, we would simply include a clause in the employment agreement that set out that that was the case. They had specifically agreed to contract in English, and that would be sufficient to meet the requirements of the Charter. Of course, if the employee wanted to have the agreement in French, we would provide the agreement in French in accordance with the requirements of the Charter. Bill 96 has modified the requirements so that in every instance where the employment agreement is a contract of adhesion or contains standard clauses, which is the case for most employment agreements, you don't see very many instances of employment agreements being negotiated, unless you're talking about executive level often. So in those cases where it is a standard, it has standard clauses and is a contract of adhesion, the employment agreement has to be provided to the employee or candidate in French first. It doesn't matter if the company knows that the employee is Anglophone and would rather have an English version. There's no exception set out to this requirement. The agreement has to be provided in French first. And then once the employee's had a chance to review the French version and has requested that it be provided in another language, then the employer can provide the agreement in the other language. In our view, this is not specifically necessarily set out, but in our view, this obligation also attaches to any other documents that you're incorporating into the employment agreement by reference. So that would include, for example, your confidentiality agreements, your restrictive covenant agreements, your IP assignment agreements that are, included as Appendix A, usually to the employment agreement. Those are part of the agreement and therefore are incorporated into that obligation to be provided in French first. Be careful of how your employment agreements are drafted now going forward, because this may even capture your employee handbooks having to be provided in French first if your employment agreement specifically says that your employee handbook is part of the agreement. The only instance, as I mentioned, in which this requirement doesn't apply is where the contract is negotiated between the parties. And as I said, this usually is only reserved for executive level employment agreements, where you'll see those being more heavily negotiated between the executive and the company before the agreement is signed. But in most cases, employees are asked to sign a standard form agreement, and there's no negotiation taking place. Next slide, please. Now, written communications. The charter now requires that employers send all written communications to employees in French unless the employee has specifically requested to receive them in another language. Previously, the requirement was that communications to employees at large, meaning to the general employee population from the company, had to be in French or in French and another language. Now, Bill 96 has extended this requirement to even communications sent to a worker in particular, and I'm quoting for the legislation. So we're not certain exactly what that means yet. It hasn't been interpreted, or we have no guidance from the OQLF about what it means, but on its face, it appears that even one-on-one communications with an employee will have to be in French unless that employee has requested to have them in English. So to that end, we have been recommending to our clients that they obtain a written opt-out from their employees who would prefer to receive communications in a language other than French that indicates that they have specifically requested to receive communications from their employer in English. Of course, only employees who really do want to receive communications in English should sign this opt-out, and it should be emphasized to the employees that signing the opt-out is optional. You don't want them to feel like they have an obligation to sign something that says that they want communications in English only. One thing of note under the legislation is even if all of the company's employees sign an opt-out to receiving communications in French, there's these three categories of documents that still need to be made available in French in at least as favorable terms as those provided in another language. So if you're providing, for example, a handbook in English, you have to provide in at least as favorable terms your handbook in French. And those categories of documents or communications are listed on the slide here, namely employment applications, documents related to conditions of employment. So here we're talking about your incentive plans, your benefits information, policies, equity plans, things that are conditions of employment of the employees have to be made available in French if an English version is also provided, or a version in another language. And training documents produced for staff also have to be made available in French. Now, I want to clarify that there are two separate requirements here. One says that all written communications with the employee must be in French. This came into force on June 1st of this year. It's already a requirement. Employment application forms, documents relating to conditions of employment, and training documents arguably are communications to employees and have to be provided in French now. However, there's a second requirement that indicates that the employer has to see to it that those documents are always available in French if the English version is provided, or a version in another language is provided. That requirement came into force, or comes into force on June 1st of next year, 2023. So to us, it appears that the legislator's intention here is that all communications have to be provided to employees in French unless the employee expressly indicated otherwise. Even if employees have indicated otherwise, those three categories of documents always have to be available to employees in French on no less favorable terms than the English or other language version. To the extent that these categories of documents are not yet available in French, employers have 1 year to translate them. The deadline ends on June 1st of 2023. Next slide, please. So now, and I think, am I on the right slide here? Can you go to the previous slide, please? Okay, so now just wanted to point out to you some other deadlines. An employee who has provided, an employee who has been provided with an employment agreement in a language other than French before Bill 96 came into force has a right to request that it be translated. So if on, let's say, April 30th of this year, they received an English version of an employment agreement, they can ask for a French version now that Bill 96 has come into force, and they have until June 1st of 2023 to make that request. And then it has to be translated by the employer as soon as possible. There is an exception for fixed term agreements that end by June 1st of 2024. If an employee asks for a translation of one of those agreements, the employer can refuse to provide the translation because it's not required. And if the translation is requested within the deadline and there is a translation that occurs and there's a discrepancy between the French and the English text, for example, then the employee can invoke either text in the event that there's a dispute between the employer and the employee, and rely on the most favorable version to them. The employer cannot ask the employee to pay anything for the translation. And I have previously addressed the last point on this slide with respect to translating the 3 categories of documents we already mentioned. So now, yes.
I would just jump in quickly, only
Sure.
because I think it may flow nicely here. One of the questions from the audience was that, would the contract requirements apply to federally regulated employees in Quebec? So like doing it in French, is there a difference there?
They federally regulated employers who are working or who are present in Quebec and have employees in Quebec still fall within the purview of the charter. And there is Bill C-13, which is federal legislation, which is coming and which will be sort of mirroring some of the requirements of Bill 96 and applying to federally regulated entities. So that is going to be captured by these requirements.
Thank you.
You're welcome. And now the next slide, please. So now the hiring process. Previously under the charter, employers were already prohibited from requiring a person to have knowledge or a specific level of knowledge of a language other than French in order for that person to be able to obtain a position, unless the nature of the duties of that position required them to have knowledge of that other language. Now, Bill 96 strictly regulates the requirement of knowledge of a language other than French in the recruitment process, and that's whether through recruitment, new recruitment, transfer, or promotion. So now, for an employer to be able to require the knowledge of a language other than French, they need to demonstrate a 3-pronged test. That they've assessed the actual language needs associated with the job duties for which they're going to be hiring, that they ensured that the language skills required of other staff members are not sufficient for the job duties that are being hired for to be met. So essentially, you have to evaluate whether other people around the job that's being hired for are already doing some of the tasks that would be required of the job in English, for example. And if those people can fulfill those duties, then you will have to limit the requirement of English for the job, or of another language for the job. And that they have restricted as much as possible the number of positions within their organization in Quebec involving tasks that require the knowledge or a specific level of knowledge of a language other than French. And as I said, this assessment also has to be done for internal transfers or promotions and not just for external recruitment. So I've had a lot of clients ask me, what does this mean exactly? How do we determine if English is really needed? We have all employees communicating with people in the US to do their jobs. So I've sort of been using this example. Let's say you have a manager who is in Quebec, who's bilingual, and that person reports into somebody in the US. They have to have knowledge of English because their manager in the US only speaks English. But then everyone who works underneath that manager only reports into the bilingual manager and doesn't have any communication really with people in the US and can speak with their manager in French. So arguably, those people who are working under that bilingual manager don't need to know a language other than French to be able to do their job, unless, for example, they're communicating with clients who are Anglophone. So you have to do this assessment internally to determine who will this person be communicating with? Will they need to communicate with someone in a language other than French? Does it justify hiring the person and requiring that they have this level of knowledge of a language other than French? Again, this hasn't been applied yet. We haven't really seen any guidance from the courts about what that means, or any guidance from the OQLF yet about this assessment. And so it still remains to be seen how it's applied in practice, but that is what the Bill 96 requires. Next slide, please. Now, job postings. Employers have to publish job postings for new hires, transfers, and promotion in French or in French and another language. When they are advertising a job offer in a language that is other than French, the equivalent job offer in French has to be advertising using means of transmission of the same nature as the offer in the other language and reaching a target public of proportionally comparable size. So you have to do your research when you're doing a job posting to make sure that the means that you're using are going to be meeting a comparable target audience for your English and French versions of your job posting. And if knowledge of a language other than French is required for the job, after you've done this hiring process assessment, the posting has to indicate why. So you have to, in all of your job postings, if you're requiring knowledge of a language other than French, indicate in that job posting why that knowledge is required. And next slide, please. Okay, so finally, what are the new employee recourses that are available? So Bill 96 sets out that every employee has a right to a work environment free of discrimination or harassment because the employee has no or little command of a language other than French, because the employee claims the possibility to express him or herself in French, or because the employee has demanded a right that arises from the charter. The employer has to take reasonable means to prevent any such discrimination or harassment if it's brought to the employer's attention and to make it stop. So this is very similar to the obligations with respect to psychological harassment in the workplace that already exist. Employers who find out about psychological harassment in their workplace have an obligation to investigate and make it stop. So the complaint that's available to employees now with the CNESST is essentially the same one. An employee will have 2 years from the date of the last occurrence of discrimination or harassment to file essentially a harassment complaint with the CNESST. Also, if an employee believes that they've been the victim of reprisals or unlawfully required to have specific knowledge of a language other than French, they can now file what's called a prohibited practices complaint with the CNESST. And that has to be done within the same deadline as other prohibited practices complaints, which is 45 days from the occurrence of an incident. So this is completely new. Before, if an employee had a complaint, they would complain to the OQLF, often on a anonymous basis. It was often disgruntled employees who would go to the OQLF and file a complaint and say that the employer wasn't meeting their French language obligations. The OQLF would investigate, send a letter asking the employer to comply. And usually if the employer complied, the file was closed and that was it. But now the employee actually can file an individual claim with the CNESST if they feel that their rights to work in French have been breached on an individual basis. Stephanie is going to talk to you about some other new recourses that are available with respect to contracts generally at the end of the presentation that would apply to employment agreements, but just essentially employees can now claim that their employment agreement is not that they don't understand it, or that it was not understandable to them if it's not provided to them in French first, as the law requires. But as I said, Stephanie is going to talk to you a little bit more about that. And on that note, I will leave it to Stephanie to take it from here.
Tanya, as you can appreciate, that last bit did generate a few questions. I will leave them for the end, unless you think that if there may be a couple that I could sprinkle in now, depending on your preference.
Sure, we can go ahead. I think I still had a little bit of time of my time left.
So I'll use a couple of general ones now, and then leave some more sort of company-specific type situations. And when I say company-specific, it's still that apply broadly, but for the end. So one question was, in your view, what reasons would be acceptable to our courts in order for an employer to safely insist for a candidate to be bilingual?
So that's, as I said, we have no guidance yet on what that means. But I think that if justifiably an employee does have to communicate with clients in English, if you're operating a call center and calls are coming in from all over Canada, that to me seems completely justifiable. If you have employees who on a day-to-day basis are, for example, designing a video game, and they're working with a team who is in California, and they're working very collaboratively, and everybody works with the studio, and without doing so, they can't do their job. Then that, to me, appears justifiable. But as I said, if you're really operating a company in Quebec that's working more in a silo, that's a lot more Quebec-based, that's dealing only with Quebec clients, and that they can report to their managers in French only, then there may be an issue there with requiring that the employees have a knowledge of a language other than French.
If I could just jump in here as well, this ties in a little bit to the part that we're going to get into about franchisation as well. When a company is asked to go through the franchisation process, they're asked to analyze the business situation and to assess the percentage of their clients, their suppliers, and the internal business processes and documentation, and the level of French basically that is used in communications with all of these people. So I think that is something that would be taken into consideration by the OQLF. So if you mainly communicate with your clients and suppliers in another language than French, not necessarily even English, just internationally, if you're a company that's from Europe and you mainly communicate in another language, that would be taken into consideration.
Thank you both. I only one more question at this stage, and I'll leave the others for afterwards, just because it tied to the CNESST. And the question is, do you think the recourse to the CNESST would also apply to employees of federally regulated private businesses?
No, I don't think so. The CNESST is the Quebec Labor Tribunal, and is specific to provincially legislated or provincially regulated employers. And so because that recourse is being created under the Quebec Labor Tribunal, it would, in my view, not be available. Remains to be seen if C13 is going to create a similar recourse under to the Federal Labor Board. I don't know. I have not looked into that, so I can't say for sure.
Thank you both. We will continue with Stephanie's part, and we'll leave the other questions for later on. And we'll have lots of fun at the end with our Q&A period.
Well, thank you, Tanya. Thank you, Gary. So let's get right into the franchisation process, which I just briefly started speaking about. So for those that maybe are not familiar with the franchisation process, basically the franchisation of a company is a set of rules that are aimed at ensuring that the use of French is generalized throughout a company. And prior to Bill 96, franchisation rules were aimed at any companies that employed 50 employees or more for a period of at least 6 months. And basically these companies were required to register with the OQLF and obtain a franchisation certificate, attesting basically that French is the language that's used within the company, and it's generalized at all levels. Since Bill 96, this threshold has basically been lowered to 25 employees within the province of Quebec. So now companies with 25 employees or more will be subject to franchisation requirements and will be required to complete a linguistic analysis of their business in Quebec. And if required thereafter, if they're not deemed to be, if French is not deemed to be generalized at all levels, they have to undergo what is called a franchisation program. And essentially to bring French up to the level of being generalized throughout the company. As is currently the case under the, or as was currently the case under the charter, companies that employ 100 or more employees are obliged to have a franchisation committee. But now after Bill 96, the OQLF also has the ability to order the creation of a franchisation committee for companies between 25 and 49 employees as well. And essentially the role of the franchisation committee is to help companies generalize the use of French throughout the company. And this can be achieved in a variety of ways. It not only is through ensuring that documentation is available in French as required under the charter, employment agreements, signs, and any type of commercial advertising and things of that nature, but also through software and internal IT being available to employees within the company. So basically the franchisation committee would also be responsible for drafting reports to the OQLF and submitting these reports every 3 years. We're just giving an update basically on the use of French throughout the company. And this is also required for any company that would be registered with the OQLF. So now that the threshold basically has been lowered to 25 employees or more, the OQLF is giving companies a little bit of leeway in order to register with the OQLF. So the deadline in order for companies with 25 employees or more to register is actually going to be in 3 years from now. So by June 1st, 2025, all companies with 25 employees or more should register with the OQLF, undergo what we have been talking about being the linguistic analysis of the company in order to obtain the franchisation certificate. Next slide, please. And so, as I was mentioning before, the franchisation committee is typically the group of employees that would be charged with ensuring that a company is generalizing the use of French throughout the enterprise. And the franchisation committee is actually usually made up of 6 employees or 6 workers. Essentially, half of the committee is made up of workers, and the other half would be made up of individuals that are selected by the management of the company. And the committee must meet every 6 months in order to hold meetings to discuss the progress of the company in generalizing the use of French, drafting reports that are required for a submission to the OQLF, making recommendations to management with respect to adopting policies to generalize the use of French, providing learning services to workers to ensure that everybody is using French as the language of the workplace. And during these meetings, also the committee is required to take minutes and to then send these minutes to the OQLF, and to make these minutes public. They must publish these minutes to and make them available to the staff. This is a new requirement that wasn't previously in the charter prior to Bill 96. Something that's also new post Bill 96 is that the OQLF can identify businesses with as few as 5 employees in key sectors, and they would offer French language services provided by a new entity called Franchisation Quebec, and provide these language services to the workers of the company, to ensure that workers are communicating in French within the workplace. Next slide, please. So some of the consequences for not obtaining a franchisation certificate in Quebec are actually quite significant. So the OQLF publishes and keeps up to date a list of non-compliant companies. So this is if you haven't registered with the OQLF when required. So when you meet that threshold and you haven't registered, if you haven't complied with a franchisation program, which has been required by the OQLF, you'll end up on this list of non-compliant companies, and the government of Quebec will refuse to enter into contracts or grant subsidies to any company that is on this list of non-compliant enterprises. The OQLF also has greater investigative powers under the charter now post Bill 96, and can inspect workplaces, take photos, access data and work materials to conduct investigations basically, and impose fines under the charter. The OQLF can also now under the charter request an injunction from the Superior Court of Quebec to force compliance with charter requirements. And as it did before, there are of course penal sanctions and fines under the charter, which have increased significantly post Bill 96. As I briefly mentioned before, there are some new entities that have been created under the charter to not only ensure greater compliance, but also to promote franchisation in general. So as I mentioned before, Franchisation Quebec is the administrative unit which will oversee the franchisation of workers within enterprises by offering French language learning services. The Minister of French Language, le Ministère de la Langue Française, is going to be responsible for generally promoting the Charter of the French language and seeks to empower and protect the French language. And a new branch of the OQLF will also be created under Bill 96. It will be the French Language Commissioner, who will be appointed by the National Assembly for a period of 7 years to oversee the OQLF and monitor the French language situation in Quebec. So let's look now at the increased penalties and other consequences of non-compliance, which, like I mentioned, are quite significant. So they've increased both for natural persons and for legal persons, so for companies under the charter. As you can see in this first chart here for natural persons, under the previous charter, in the column, the middle column, there were essentially 2 tiers to penalties that could be imposed. There were penalties for a first offense and basically for a second or subsequent offense. And under the charter now, post Bill 96, there are 3 tiers now to penalties that can be granted, and they've increased significantly. So for a first offense, the penalty for natural persons, so for individuals, the first offense can range between $700 to $7,000. Second offense is between $1,400 to $14,000, and any subsequent offense would be between $2,100 to $21,000. For legal persons, the fines are even greater. And essentially, fines for legal persons between a first offense and a subsequent offense can range between $3,000 to $90,000. So these penalties are currently in force. They came into force as of the date of assent of Bill 96. So as of June 1st, 2022, they came into effect. And what's important to note under the new charter post Bill 96 is that an offense that continues for more than one day constitutes a separate offense. So every single day that an offense continues will constitute a separate one. So the fines can increase significantly for one single offense. It's also important to know that any offense that's committed by a director or an officer a director or officer basically is presumed to have committed an offense and can be held personally liable under the charter unless they've exercised due diligence. And fines that are imposed on directors or officers can essentially range between $1,400 and $42,000.
Stephanie, what the due diligence that is expected from directors? Would you be able to speak a bit more about that? Like, what would that look like?
It hasn't been interpreted yet as many of these new provisions under the charter, but essentially what we anticipate is that it'll be similar to much of the case law in other penal and sanction divisions. So that exercising due diligence would essentially be putting policies and practices in place to ensure that any violations would not happen. So that would be in trying to ensure that there is compliance under the Charter of the French language, and that any type of violation that's happened is a mistake, essentially. And so it would be important, therefore, for companies and management to ensure compliance with the charter and be aware of their obligations under the charter in order to benefit from this type of defense.
Sorry, Tanya, go ahead.
I was just going to add that in our experience, the OQLF has communicated with entities that are non-compliant when they receive a complaint, or even when they become aware of, let's say, a website that's only available in English but should also be available in French. They communicate first with that entity and tell them they're not compliant, and if you comply, typically, as I said, that the file usually gets closed. So I think that part of that exercising due diligence is probably complying when asked to comply. Typically think that fines are sought when a company is asked to comply and doesn't do anything about it.
And there were a couple questions just sort of wanting confirmation that the 25 employees were not necessarily referring to company-wide, but based out of Quebec, 25 employees.
Correct, yeah. 25 employees registered in Quebec, essentially, and it's over a 6-month period that basically the employees are accounted for.
Yeah. So the essentially the anybody that had, or now the new threshold going from 50 to 25, a company may be extremely large, but it doesn't have 25 people in Quebec. It's not the same application.
Exactly.
Correct.
Thank you. I will hold the other questions for later on, but just jumping in with small points of clarification for housekeeping.
Great. So just to continue on, just as under the previous charter, so there's these fines and penalties that we were talking about. Of course, non-compliance can lead to having a franchisation certificate suspended or withdrawn completely. What's also new under the charter as of now is that the OQLF can apply to have orders issued by the can have administrative orders issued, and these can only be contested then before the Administrative Tribunal of Quebec. The OQLF can also apply for injunctions to force compliance, and this is done then before the Superior Court of Quebec. And obviously any type of proceedings of this nature can end up being quite costly if it results in litigation. So we also touched upon the fact that the OQLF will have some broader investigation powers to ensure compliance under the charter. And we've listed these powers here. These are the 4 ways that the investigators can come into the workplace and essentially investigate. So they can enter at any reasonable hour, any place other than a dwelling house where an activity governed by the Act is carried on, or any place where documents or other property to which the charter applies may be held. So this would include obviously a workplace. They can take photographs of the place and of the property located there. They can cause any person present who has access to any computer equipment or other things that is on the premises to use it to access data contained in the electronic device, computer system, or any other medium to verify, examine, process, copy, or print out such data, and require any information relating to the application of the charter or the regulations, as well as communication for examination or reproduction of any related document. Anyone who has custody, possession, or control of documents must communicate them to the person making an inspection and facilitate their examination by that person. Prior to the inspection, the inspector from the OQLF will send a notice and require the communication of certain documents. So these are quite broad powers. Prior to Bill 96, that didn't include the powers to access computer documents or data on any type of electronic devices, or to explicitly make reproductions of things. So this is quite broad investigative powers. But we look forward to seeing how the OQLF will actually exercise these powers in the future.
Yeah, and to that, I just feel like I need to interject here, because these powers are very broad and I mean, even surpass what the police would need a warrant to go and do if this was a criminal matter. So remains to be seen whether this is challenged. I don't know if, and it was in the news last week that 2 of the provisions of the charter have been suspended due to a constitutional challenge. Proceedings that were filed in English under Bill 96 now had to be accompanied by a certified French translation. Those provisions have been suspended by the Superior Court of Quebec as of last week, pending a final ruling on whether or not those articles are constitutional, or whether they breach the charter's, the right under the charter to appear before justice in the language in either of the official languages of Canada. So we'll see. And I wonder whether these particular provisions will also be challenged to a certain degree, because they do very much broaden the rights of the search rights of the OQLF.
Absolutely. I mean, I've already had clients that have asked to what extent the OQLF would have the right to any type of proprietary information and things of that nature. I mean, the scope of this is that they have the right to anything that is within the scope of the charter. So there might be an argument to be made there that any sort of confidential or proprietary information is out of scope of the charter. But it remains to be seen how they will actually enforce these types of things in these investigations. Next slide, please. So as Tanya mentioned, there is a new right of action under the charter. There is a civil right of action that any type of that any individual can bring against a company or anyone that has violated a right under the charter. This new right for the civil right of action does not apply to a violation of the consumer for goods and services, the right essentially to be informed and served in French if the company employs less than 5 people in the province of Quebec. So this is good news for companies essentially that don't have a large presence in Quebec, that essentially just have a small office here in Quebec, do a little bit of business here, that mainly have online maybe services that they provide. But essentially there is a new civil right of action. So this is a potential for class actions that individuals may bring under the charter. And it remains to be seen how this will actually play out in Quebec. And as we've mentioned before, so any repeated contraventions of any requirement under the charter could give rise to the suspension or revocation of a permit or authorization, not only under the charter, but also any type of permit issued by the government. Because as we mentioned, the government does keep an eye on this list of non-compliant companies. So any contracts or subsidies granted by the government, they could be revoked. Provisions in a contract that cause injury to a injury by contravening requirements under the charter can be annulled on the application of a person who suffers the injury. So this is essentially in contracts of adhesion that this would apply. And any clause drawn up in a language other than French that is deemed to be, any clause drawn up in a language other than French is deemed to be incomprehensible unless the contract was drawn up in that language, in that other language on the adhering party's express consent. So this once again would apply in contracts of adhesion. So it needs to be drawn up in French first and provided to the adhering party in French, failing which the contract will be deemed null and void and incomprehensible. And this would apply also in situations of employment contracts, as Tanya mentioned earlier. So just to sum up briefly with some of the key dates that we think would be most useful for everyone to keep in mind. The new employer obligations and penalties and recourses are currently in force. So it would be important for employers and businesses to review their policies and practices to ensure that they are already in compliance with these new requirements under the charter. As for the translation of existing employment application forms, documents relating to conditions of employment and training documents, there is a little bit of leeway time for that, and companies have until June 1st, 2023 to get prepared for that. And with respect to the registration with the OQLF and the franchisation process, companies have until June 1st, 2025 to prepare for that process. And we would be happy to assist anybody with that process and answer any questions that you may have about it. So I would love to open up the practical considerations and questions session with Gary and Tanya and myself.
Thank you both, and it is lots of questions have come in, and we'll happy to take more as we start chipping away through these. And in no particular order, I'll try to give some sort of, and I'm combining some of them for the sake of making it practical. So if it's one of the questions, if it's a SaaS company that doesn't have Quebec employees, but offers SaaS services in Quebec, like the platform themselves. So by SaaS, software as a service, for the audience as well. I've learned to not use acronyms more than I have to. Essentially, the platform is translated, but some of the training materials and so on are not. Now, the clients using this on behalf of this SaaS company will have Quebec employees. What does this company do? Do they need everything translated? Do they need like these training materials, YouTube videos, and Word documents, etc., that go along with as training materials for this software solution?
Yeah, that's an interesting question, because the company itself doesn't fall under the purview of the charter. They don't have obligations because they might have obligations under the charter to a certain extent, but they don't have employer obligations under the charter. So to the extent that they have to meet the requirements for their clients, they don't. Their clients are the ones who need to be meeting the requirements of the charter and offering training in French or training in a language other than French. So the company itself can continue to provide English only training, and the burden is on the employer who's using their services to locate potentially an equivalent French language training, or provide an equivalent French language training, and provide materials if materials are being provided. For example, if they have a slide deck that is being provided to the employees in English, to have that translated and provided to their employees in French.
And Tanya, I'm actually, now I'm asking something that our clients have asked us at Alexa. So as you know, Alexa has the professional services division as well as an AI software solution as well. So, and some clients have asked, look, there's certain internal communications, et cetera, that we may not get to doing professional translation. Do you think we could just do AI translation, being that it's being trained for our purposes? And what are your thoughts around that?
Yeah, that's so there's no requirement in the charter about the quality of the French that needs to be met, right? It has to be provided under equivalent terms. So arguably that could be interpreted as meaning a good translation, a translation that's well done. But if you are pressed for time and you really need to meet your requirement to have something in French, then perhaps it's best to have something in French and take the time you need to make it perfect thereafter. But of course, as a lawyer, it's difficult for me to advise anybody to have any sort of legal document made available in a language that has not been reviewed by attorneys. Stuff I don't know.
And I mean, that's certainly the best advice, is always have the best translation possible.
Yeah.
And it's interesting because, when we've been asked those questions, it's really been that, look, it's better to have French with small imperfections than not to have French at all. That's certainly a better situation, but obviously always strive to have the best way possible. I just thought it was worth asking. I will move on to another question, and this is around postings. So if you have an employee that, or you're posting a job posting saying that we need somebody bilingual, is it acceptable, for example, to say, look, we're servicing areas of Quebec with big Anglophone communities, so we need somebody that is bilingual, for example?
Probably. Steph, I don't know if you have any other views on this, but in my view, as long as you put something in the job description that justifies why you're asking for it, you're meeting that requirement. Whether your assessment is sufficient, the OQLF could maybe come and see and audit, but I think what they're looking for is that the assessment has been done and that there is something in the job description that justifies the need for a language other than French. And if you're doing that, then you're meeting the requirement of the legislation.
I agree with that. I think that it is better to document the assessment and keep that on file. But there's nothing in the legislation that specifies that either. It is just, I think, in the franchisation process as well, that it's just best to keep that on file and in mind in case any questions are asked.
And just one quick housekeeping item. We had planned 90 minutes for this, so I'll continue to answer, to ask some of the questions to Stephanie and Tanya, understanding that some of you may have to drop off. This will be recorded and you can access it afterwards as well, but I encourage you to stay if you can, because nothing better than continuing this live. So another question that came up is, does it make a difference? So if there is a Quebec employee versus with a parent company versus a third party when it comes to ability to communicate?
I'm not sure I understand the question.
And I'm trying to give it the interpretation as well as possible, being that the question is written. But if the communications are not with the Quebec employee and third party, but Quebec employee and the parent company employees in Ontario, for example.
Oh, I see. So if the communication is coming from a parent company that's not in Quebec, there's no exception for that. If the employer has employees in Quebec, it is the employees in Quebec who have the rights that are associated with the employer obligations. So they have a right to receive communications in French, and there's no distinction between whether it's coming from outside of the jurisdiction or not. So arguably, if let's say there's a Quebec entity, a subsidiary, but that the communication is coming from corporate in Ontario, technically it's going through the Quebec entity to get to the employees in Quebec and would have to be available in French.
I actually have another question tying it to subsidiary, so I will try to package it together with this one. So sometimes employees are reporting to more than one organization, for example, bank and subsidiary within the bank. Mm-hmm. So the assumption for the purpose of determining the number of employees in Quebec is to establish, in order to establish whether to apply for the certificate. Would the clients have to look at the employment contract and who the entity that it's signed with to determine this for the purpose of the certification?
Yeah, for the purposes of franchisation, I think so, Stephanie, and maybe, do you want to take this one?
Yes, I mean, it would have to, the companies would have to look at the employment agreements to determine which employees belong with subsidiaries or which entities, and it ultimately comes down to how many employees are declared in the corporate registrations as well. That'll come into play for the OQLF. That's what they're going to look at ultimately. So making sure that the corporate registrations are up to date would be really important as well.
And would there be double counting of the employee headcount for the subsidiary, as well as if the employee in question also supports a subsidiary in Quebec, which may require the sub to also have to apply for a certification?
That's a good question. I think that one we'd have to look into that one a little bit further. Maybe provide a legal opinion on that one.
I figured that may be a bit more complex, and we'll connect you offline. This one, just more housekeeping quickly. In terms of as it pertains to the penalty chart, what is a legal person? I assume it's including physical as well as corporations. That's the sort of the definition for this context.
No, so
it's corporations, associations, and partnerships.
Okay.
Yeah, so a legal person is essentially a company in various forms, and a natural person is a person, an individual.
Another interesting question. So if a partner in a law firm is considered is a partner in a law firm considered an employee for the purpose of the charter of the French language? And I'll give you both scenarios. That sometimes you have partners that are sort of non-equity partners and partners that could be even incorporated as a partner through a corporation. Would that make a difference? What's your opinion?
That's a good question. They're not employees for the purposes of employment standards legislation. I don't know. I'd have to look into it.
And again, it was one of those that it's because it would apply a bit more broadly than just that. It would apply to accounting firms and sort of organizations where partnerships of this nature are allowed, engineers, etc. So it is interesting, and that makes a lot of sense.
Yeah, because they're for most intents and purposes, they're not employees. So I wouldn't be surprised if they were excluded from the charter in terms of employer obligations, employee rights, but I can't say for sure. I'm sure there's some case law.
100%. In the case of access to a computer, would this mean that French-speaking employees will no longer be allowed to use a computer that is set up in English? Does the computer need to be set up in French? Let me to rephrase the question. Will the computer have to be set up in French for Quebec-based employees?
I think there's two ways to answer that. I'll take the non-franchisation answer, and Steph, why don't you take the franchisation answer? But there's an obligation under the charter to provide software in French unless a French version doesn't exist. And so if your employees in Quebec are using, let's say, the Office suite, which is available in French, you have to provide that to them. They need to have the option, at least, to use it in French.
And if companies are subject to franchisation measures, what is recommended or preferable is to set everything to default being in French. So having French keyboards being available, having French software being the default, having everything basically set up in French, unless it's a requirement for the job or really an employee preference for it to be in English.
So this is a question that had come through before the presentation, but it ties in a bit to this and opening it again to both of you. So let's say it's a proprietary tool that had been built by a client or sort of by a company, and it was done in English. Would they have to figure out a way to do a French version of this for the Quebec employees? I assume yes, but I thought it's worth asking the question.
No.
Okay.
Yeah, good news. No, the software obligations haven't changed under the charter. It's one of the aspects that weren't touched by Bill 96, and it's been determined, and we have benefited from interpretation of that provision, that there's no obligation to create a French version if one does not exist. So if you only have an English version of the software, it's fine to offer it. If the French version doesn't exist, you don't have an obligation to create a French version, even if it's your software. And if you are going to provide a French version, it has to be equivalent to the English version. You can't just put out, a subpar French version. So contrary to what we were discussing before about just trying to meet the obligation as quickly as possible, you can't do that for software. You have to put out an equivalent version. So best to not necessarily try to go and create a new software unless you're really invested in it.
I'm sure that's very helpful to much of the audience. Is there any guidance on social media and how to use national company accounts that also target Quebec?
There are. Steph, you can probably speak to this more than I can. Those have been interpreted. There is quite a bit of guidance on the OQLF's website. They have interpretation guides, right, Stephanie?
Correct. Yeah, the OQLF has a whole guide on how to basically run your social media so that it meets the charter requirements, and basically different options of how to set up either two separate social media accounts or how to basically have one social media account that is bilingual and compliant with the charter requirements. I think that a lot of companies, a lot of our clients tend to prefer having two separate accounts, just because the French will tend to confuse their clients in the rest of Canada or in the US or elsewhere in the world. But when doing the separate accounts, you have to ensure that the French version is equivalent.
Yeah, and it's quite detailed. I think, unfortunately, it's only available in French, if I'm not mistaken.
It is.
Yeah,
it is.
but it is there, and it's quite detailed and helpful.
It is. Yeah, it's very helpful.
So this is also an interesting question that affects a lot of sort of HR communications departments internally. Even with an opt-out, what do you suggest as a best practice for parent companies in Ontario with subsidiaries in Quebec? When you want to have a company town hall, do they have to be bilingual? Does it apply to only written materials, or does the company have to worry also about the sort of conversations, company-wide video communications? And if they recorded this, would it sending it out afterwards, would that be considered written communication?
So the requirement only applies, the very specific requirements only apply to written communications. There's this general right of employees to work in French, and the corresponding employer obligation to make sure that the employees have a right to carry out their work in French. There's nothing specific about training, town halls, verbal communications, or anything like that. Arguably, if you're telling somebody that they need to have a specific knowledge of English in order to be able to have these types of conversations with people who are outside of Quebec, that it's justifiable to have them participate in these meetings that are in English only, without necessarily having to provide a translation. But you should have somebody available who can answer questions, make things clearer, potentially send out the same message in French to those employees who are francophone or who have a difficult time understanding English.
Yeah, very insightful. And so now, when reaching out to potential job candidates known to be located in Quebec, must an employer communicate in French if the job posting also allows for remote working from anywhere in Canada?
Oh, that's a tough one. It's actually come up with some of my clients. Our recruiters are Anglophone, they're not in Quebec, they can't speak with people in French in Quebec. So what do we do? I think the answer to that is you have to adapt. You have to find a way that if you're trying to recruit somebody in Quebec, that they have the option to speak with somebody in French. Often what that looks like is having a on-the-ground HR person in Quebec who can do the recruitment of a person who demonstrates a willingness or a need to interview in French.
Another really interesting question. So could you revisit the foreign employer's obligation to merely communicate with its Quebec employees? So for example, in the case of a US bank or insurance company, can the CEO based in New York or Washington send an email or video clip message to the Quebec employees exclusively in English?
No. Unless they have specifically opted out, right? So if and I had this discussion with a client just yesterday, what's the point of them opting out if you have one person who says, I want to get things in French? You have to create bilingual everything for that one person. And in theory, that's true. That one person has a right to receive those email communications that are coming from the employer, because you're not talking about just an individual communication from the CEO to that one person. It is a communication at large from the company to its employees, and that under the charter has to be in French or in French in another language.
Does the B2B website that is not directly directed towards any consumers have to be available in French?
Now we're foraying outside of the employment realm.
I think so. I think this is a bit broader, and I'm not sure. We can leave that for now.
Yeah.
On the same trend though, as earlier in terms of, and this is specifically referring to trainings, does it have to be so virtual or face-to-face trainings? Do they have to be delivered in French?
Yeah, I think that was addressed previously, that there's no obligation for the person for anything verbal to be done in French only, other than that obligation that workers have a right to carry out their work in French.
They asked for it.
Yeah. I have had client, even before Bill 96, I've had clients tell me that they did a training and some employees walked out because it was in English only, and they said, I don't understand any of this and I'm going to leave. And essentially the employer couldn't really do anything about it because the training was in English only. And their solution was then to offer the training in French as well.
And I think from a practical perspective, Tanya, I think that's what it comes down to, that offering the training bilingually is ultimately a solution despite the legal obligation here.
Mm.
And another question that came up, and I'm not sure that it's necessarily tied to this, but the example was, can an employer with a head office outside of Quebec, for example, in BC, insist that their employees write their communications in English? I can't imagine that would be the case, but
well, technically no, but I mean, if they want to be understood, what else are they going to do? If their manager is an Anglophone sitting in BC and they want to be understood and do their job correctly, they're going to have to communicate with them in English. The employer can't. The employer could technically discipline somebody who is not meeting the requirements of the job because they can't communicate with their manager or their supervisor. But I
think it would be important for the job posting to have been explicit in saying that English was a requirement of the job. And failing that, it's highly risky to then discipline or do anything else vis-a-vis the employee. Now that there's this right to a complaint to the CNESST, which is post Bill 96, a pretty broad right to complain to up to 45 days, Tanya, or is it 2 years?
Well, it's 45 days for the prohibited practice and 2 years for the harassment and discrimination complaint.
So it's the 45-day one.
But it's a funny, question, because practically speaking, it wouldn't really come up. But if the job posting clearly states you have to be able to communicate in English, and then they don't, then an employer can take steps to remedy that.
So and I will ask one more question and then wrap it up, knowing that we're approaching time. For new hires, you can specify in the job post that English is required if justified. But what do you do with longtime employees for requiring them to communicate in English, or when you promote them and the promotion requires English, for example?
So the first step there would be to ask them if they sign an opt-out or not, right? But then the requirement to speak a level of a language other than French for a promotion, you have to do that same assessment. You have to justify the need for English, and you have to determine whether somebody else can do the job or those parts of the job that would need the English. And you can't not promote somebody because they can't speak a language other than French if the job doesn't specifically require it.
Oh, and that makes a lot of sense. It has treated almost like a new job in posting entirely, which makes a lot of sense.
Exactly.
Well, I appreciate the time from both of you, and certainly the audience is encouraged to reach out to you directly for any questions beyond this. But it's been very informative. Actually, somebody from the audience asked if they could have a copy of the presentation. The short answer is no, but you could actually record. You could watch the recording at any time. Feel free to sign up and watch the recording, especially for any colleagues that missed it. We thank you all for attending today, and then a special thank you to both Tanya and Stephanie for the time today and their excellent insights. And we look forward to having you continue to attend our series on Bill 96 as this evolves, and hopefully we'll have more guidance over the next little while in some of the directions. Thank you all for attending again.
Thank you for having us, Gary.
Thank you.
Pleasure as always.